When drafting an arbitration clause, inexperienced arbitrators may overlook the seat of arbitration. Experienced arbitrators, however, know that discretion in choosing the seat of arbitration, known as the lex arbitri, is imperative to ensuring the process goes smoothly. It is absolutely at the forefront of a successful arbitration. The seat of arbitration is often, but not always, the place the arbitration itself will occur. Therefore, it is logical to assert some geographical factors that come into play. Parties to the arbitration may look at cost, accommodation, travel, and food. These can be helpful to look at, but are by far lesser factors when choosing the seat. This is because the seat of arbitration is more importantly the legal jurisdiction of the arbitration. So, what does this mean? Well, in arbitration, no matter the governing law of the contract or the nationality of either party, the law of the seat governs the process of arbitration itself, the legal framework of the arbitration. It therefore can play a crucial role in numerous factors. For example, whether a dispute is arbitrable. Each seat of arbitration generally has its own legislation dedicated to international arbitration. For example, if the parties chose their seat as Singapore, the International Arbitration Act of Singapore would govern their arbitration. This legislation sets out, among many other important rules and regulations, what can and cannot be arbitrated. For example, public policy disputes are not arbitrable in Singapore. Every seat has different rules, so it is important to check if your dispute is arbitral in your preferred seat before deciding. Now that it has been established that the dispute is arbitrable, the seat also has an impact on the procedure of the arbitration itself. Parties may incorrectly assume that the institutional rules they chose, as well as the clause itself, will form the rules of the procedure. However, the relevant statute of the seat can also have an impact on proceedings. As outlined by Gary Bourne in his book International Arbitration Law and Practice, different issues can arise depending on the seat. Each seat has varying levels of prescriptive rules about the proceedings, and parties generally choose seats that are supportive without being disruptive. The courts are an incredibly important factor when choosing a seat. This is because the extent and manner of intervention of the courts in the arbitral process is dependent on the seat and its laws. Some will have minimal intervention while others will intervene significantly, which can severely impact in the principles of arbitration. Generally, pro-arbitration courts intervene only when necessary to preserve the autonomy of the arbitration. This arbitration-friendly intervention by courts includes enforcing arbitration agreements, expediting procedure, granting emergency interim relief, interlocutory measures, and other intervention to support the arbitral process without undermining it. After the delivery of an award, the seat still carries importance. The courts in the seat often have the ability to allow a challenge or an appeal of the award. As one of the principles of international arbitration is often finality of the award, the best seats generally offer little or no review of merits of the decision made by the tribunal. However, some will permit extensive reviews of merits. As previously mentioned, it is usually recommended to find a seat that's relevant statute is based on the UNCITRAL model. Sometimes overlooked, the seat has a greater impact on the choice of arbitrators than parties sometimes realize. Often, the arbitrators are sourced from the seat, therefore possibly restricting arbitrators with specific language comprehension, expertise, or legal training. Secondly, as noted by Bourne, the national legislation of the seat imposes restrictions on the nationality or religion of the arbitrators. Finally, and most often importantly, whether or not the seat is a contracting party to the New York Convention is generally regarded as one of the most essential factors when choosing a seat. As noted by Bourne, if the seat is not acceded to the convention or a comparable instrument, the award made by the tribunal may not be entirely enforceable. Without, the award will likely be enforceable in the seat itself, but may be null in outside states. If the seat is a party to the convention, however, then the award made will be enforceable in other contracting states. This is clearly very important in international commercial disputes that may have their places of business scattered around the world. Over time, some seats have been known as safe bet seats. These seats are known to have favourable law and are often based on the UNCITRAL model law. These include Paris, Geneva, Singapore, Hong Kong, and London. Overall, by looking at all the combined factors, parties have the tools to select an arbitral seat that supports instead of hinders the overall process, and will hopefully produce a smooth and successful arbitration. Happy arbitrating!